The case of Fagan v. Metropolitan Police Commissioner is important for several reasons. Firstly, Lord Chief Justice Parker set the definition of an assault. Secondly, it established that a battery can be committed by indirect application of force. Thirdly, it demonstrates how an omission can be reclassified as a continuing act so as to form the actus reus of a crime. It also demonstrates how this principle can be applied to avoid the contemporaneity rule requiring the actus reus and mens rea of a crime to coincide. A policeman was directing the defendant to park his car. The defendant accidentally drove onto the policeman's foot. The policeman shouted at him to get off. The defendant refused to move and switched his engine off. The legal arguments. The prosecution argued that the defendant had formed the intention of applying force and had indirectly applied force to the police officer. The defendant argued that at the time of the actus reus, the driving onto the foot, he lacked the mens rea of any offense since it was purely accidental. When he formed the mens rea, he lacked the actus reus as he did nothing, and an omission can't form the actus reus of a crime. It was held that an assault is any act by which the defendant intentionally or recklessly causes another person to apprehend immediate and unlawful personal violence. Although assault is an independent crime and is to be treated as such, for practical purposes, assault is generally synonymous with the term battery, and is a term used to mean the actual use of unlawful force to another person without his consent. There was an act constituting a battery which at its inception was not criminal because there was no element of intention, but which became criminal from the moment the intention was formed to produce the apprehension which was flowing from the continuing act. He remained seated in the car so that his body through the medium of the car was in contact with the officer. He switched off the ignition of the car, maintained the wheel of the car on the foot, and used words indicating the intention of keeping the wheel in that position. The driving onto the foot and remaining there was part of a continuing act. Such conduct can't be regarded as mere omission or inactivity. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.